Right, that conclude this matter.
So you just let this dumbass bitch just do that? It's not.
Baby, with friends like these, who needs enemies? Be careful on who you bring to court with you. I don't know what stupidity was happening this particular day, but we're getting ready to go to court. We're going to check out a couple of cases. We are going to go to court and get into when is it ever okay to make a deal? Let's make a deal. This is like, let's make a deal court. We have a tenant who has a writ of execution already filed against her, which we know means they've gone through the whole process. She owes the money. This is the money that she owes. And she has filed a motion to stay or a motion to set aside, meaning don't enforce that particular writ of execution, or I'm sorry, writ of eviction. There is such thing as a writ of execution, but that's a whole different kind of thing. All right, so writ of eviction is already filed. And she wants them, she says, Judge, Your Honor, please don't do this. All right, we're going to go ahead into court. Make sure you like the video, like, share, subscribe. It's, free advertisement, free help for the channel. And of course, we are going into the court of public opinion, Mrs. Fields. So thank you, Mrs. Fields. And let's get into court. Ooh.
Yep. I got it. Go. You hand me my screen box.
Now go free. This is case number 2405766, Kelsey Point Woods Partners versus Janiyah Daniels, and that's Jainaijx.
This is recent. This is November. I said February. Lord, I'm tired. This is November 2024. November.
Afternoon.
That's me, Denasia.
And what's your last name?
Daniels.
Okay, Ms. Daniels, let's see. This is today's schedule for your motion to stay proceedings. You wrote in on October 16th. You're asking for more time to pay your past due balance. There was no excuse of comes responsibility, but your health played a major role in it. Getting back on track, willing to put your best foot forward and get on a payment plan if possible.
Yes, ma'am.
You just started being able to work again last week.
Yes.
Thank you in advance for allowing me more time. You don't want to leave. I just need more time, and I will have everything paid up. And so I'm looking. Writ of eviction came in September. It says the judgment was from October 14th. At that time, you had paid $1,800 on the judgment. It was a default judgment, meaning that you didn't appear in court at the time.
Okay.
And so it was a possession judgment.
So the rehashing of these details, one, ensures the court has the proper file in front of them, that they are speaking to the proper facts. And then two, it makes the party aware you didn't dispute any part of the eviction process, the unlawful detainer. So clearly you agreed to all of the monies owed. So that's not a reason why you want to change. Remember, to have a motion set aside or to stay a judgment, you're looking at, okay, did you have a good faith effort as to, why this is or isn't the case, why it should be upheld or not, most likely, why it should not. And secondly, what are your defenses to it?
Judgment entered for $5,000.
Only statements of facts. Okay, I hope you guys can see and hear me. The only statements of facts that are in question of any sort is that she is stating factually everything that the landlord has presented is correct. She just wants more time to make the payments and wants to get caught up in reasonable time. She just needs extra time.
$164.60. If you paid $1,800 way back then on that, and this is just up to that point, that would have left on the original judgment $3,764.60. And that, since that was dated August the 14th, now we've got September and October and November. Had you made any more payments other than the $1,800?
No, ma'am. They wouldn't allow me to make any more payments.
Okay. How much do you show that she's currently due now, adding on? I would have, as to the judgment amount, if you apply that $1,800, it'd be $3,764.60.
Wait, my balance is showing $8,726.02. When was the $1,800 payment paid?
I don't know. That's what you all said on the writ, so I don't know what you paid.
I calculator. Yeah, no, I'm showing, that's correct. That was paid. It looks like it was paid on August 9th.
So she owed $3,764.60. How much would it break, if you can break it down, how much is it per month for August, September? So, for September, October, and November.
It's the monthly rent is $1,440. Looks like about a $14 gas charge, $5 trash charge, $3.50 service fee, and then it looks like about water and about $26 a month, and then sewage and about $37 a month. I have a ledger, Judge, if you'd like to look at it.
Every lawyer's favorite part.
Just said, let's see what cost that might be per month. That's not including the late fee.
Yeah, there's a couple $100.
There is a lot of
Late
math.
fees added.
Real quick, there's a lot of math, or in landlord tenant law, there's math to be done. In family court, there's math to be done. In probate court, there's math to be done. So it's like, yeah, you know, some lawyers may run away from math, but there's a gazillion of opportunities to be stuck in doing some math.
Your total was $8,726.02, and that's probably, let me see if it includes the $1,800 you paid.
Yeah, it's in there. It's subtracting out on August 9th. If you look at the date.
Okay, well,
This court reminds me, the setup of this court gives me flashbacks to the YSL case, or wait, is it YSL? Yeah, Young Thug, Mr. Jeffrey Williams, just because of the color of the desk is, it just, I don't know, it feels like school. But it's a courtroom, but it feels like school to me.
that's a whole lot of money.
You see the dark wood. I like the dark wood the most.
The standard $8,726.02. How you gonna pay that?
Yeah, how we gonna pay that?
I have half of that now already.
Okay.
Okay. So what's half of that?
About
Is this Washington D.C.?
4,000.
Okay, so that would leave you another $4,726.02. What's your proposal to get that paid?
I was hoping that I could get on a payment plan to pay that,
What kind of a payment plan?
like monthly or bi-weekly.
Ma'am, I can't read your mind. I don't know how much you're talking about.
Okay, yes, this is Washington D.C. court. I believe. So, well, it says SO, so that's not Southwest or Southeast, but it comes up as a district court in D.C. Maybe it is, maybe it isn't. But interesting enough, when you put in your motion, when you are the moving party, you have to know what you want as the result. So if you're gonna put a motion against the other party, what outcomes do you want? So when the judge is like, okay, so what's your proposal? You're supposed to know, I propose that I pay $500 every 2 weeks, beginning next Friday, the 16th, and twice a month, in addition to my other rent. Like, have the proposal that, one, you know you can follow, two, that you believe will catch you up quickly, and three, that the other side is most likely going to be able to accept. And maybe you don't start at the $500 because you want to have some wiggle room, so you start at $400. But come on, you got to have the proposal.
I don't know when, and this is your proposal, so you can't tell us more information.
Well, what will the court allow?
Okay, you want a payment plan. You have to propose the payments and the plan. We can't do that for you.
Right.
How much are you going to pay to catch up, and when are you going to get it
It's
paid?
not the court's decision. This comes up later, I believe. But just to be clear, it's not the court's allowing your amount or not. This is what the leasing office and the landlord will accept in order for you to become current.
About $250 a month.
That's not nearly enough for them to want to do this, as he's shaking his head here. So you're talking about paying your regular rent on time and carrying a $4,000 balance for which you're going to only pay $250 a month. So if you were to do that, that would mean it would take you 18 months, almost 2 years to catch that up. And that's probably not that reasonable.
Well, that's just give or take.
It's just like a ballpark. You
Like a
pay
ballpark.
more.
I can probably pay more.
That's just me not wanting to obligate myself.
I say this a lot, and this case is going to show you one of the major reasons why this is important. One, when you're on Zoom court, you're supposed to be showing your background, and you're supposed to be, confirming that you're the only one there because you're testifying on your own behalf, or you are communicating facts to the court on your own behalf. You are not supposed to have someone else there coaching you as to what to say. And this person is completely coaching her as to what to say, and it becomes a problem. Just wait.
Well, if you could pay more, why wouldn't you suggest that to us? Because this balance is so high. Most landlords are willing to work into a payment arrangement, but it's got to get it paid way sooner than 2 years later.
I don't want to put myself in a situation where I'm not
I don't want to put myself into that obligation. I know
You
my
might
health
want to
is.
just
Okay. She's going to say she doesn't want to put herself into that obligation. You did that when you signed the lease agreement. And just another thing I want everyone to hear is that a lot of landlords prefer that you resolve the balance within 1 to 2 months. They're not trying to go 6 months, 7, 8 months into the year.
sooner than 2 years later.
I don't want to put myself in a situation where I'm not represented.
I don't want
mean,
to
if
put
you
myself into that obligation. I know
You
my
might
health
want to
is.
just consider finding a spot that you can start over and afford, because
Oh, this balance on top of that.
Right, but then I will owe this balance still in addition to the
And
new
you
rent.
just contradicting what
well,
you
you're gonna owe this balance still in addition to new rent
but I
here.
will just say
It does, it's 6 of one, half a dozen of the other. It's the same problem. Whether you move out,
It's actually a little more to move because you have to have the deposit, you have to have the security deposit, the first month's rent, and moving ability, physical ability, or be able to pay someone to do it and actually move all things. So yeah, it's less hassle to move right now, but the judge is correct in the sense that you're going to be running this balance regardless. And I guess what she's really trying to get the defendant to understand, or I guess in this instance, the petitioner to understand that you're going to owe the $8,000, but if you have $4,000 in your pocket, you have $4,000 to go towards moving, and now you have an $8,000 judgment against you that you pay off in increments over time to the best of your ability. Same difference there, except for you're getting out now. Whereas if you stay into the property and you're looking to make that $8,000 up, you pay the $4,000, you no longer have that savings, and now you're hustling to make these other payments. And like you said, if you get sick, you're back here easily, quickly. You miss a payment, they're
Or whether you stay here. The difference being, if you
I would rather
move out,
it's going to be quick, because be concise. It will be a quicker process with the current landlord because they already have a writ of eviction against you. So they already have the judgment against you. All they have to do is get you out.
or whether you stay here. The difference being, if
I
you
would
move
rather
out,
stay here.
I cannot afford.
okay, ma'am, I would rather you stay there too. But you signed a contract that said how much money you were able to pay for rent. And I understand things happen, and you're really behind. It's not like you're behind 1 month. You're behind 3 months.
I'm sick.
I know, I'm aware of that, but I'm sick. I have renal disease.
Okay. Well,
That's quite unfortunate. We did have a tenant in previous videos. I think it was our Karen tenant, part 1 and 2, who had ailments of a new kind for me. I have not dealt with that before. Who had very strenuous ailments, and it was making it hard for her to move out. She ended up staying there for over a year. Go check that video out. But in this video, at least the young lady does have some reasonable actions that she's trying to take to rectify her wrongs, or her financial obligations, I should say. But sickness is not a defense to owing a judgment. Okay. I am very interested in where this court is. We have pictures of people. I don't know if that's Martin Luther King, but we got two little girls, look like school ages, and just some lovely people being displayed in court. I've never been to a court that has this. This is very nice.
listen, I can't listen. I can't make this arrangement. The landlord's going to have to agree to it. I'm just trying to get the information, and I don't know of any landlords that say, okay, you can just stay here because you're sick. And even though I appreciate the fact that you're ill, things happen, you got sick, you couldn't go to work. I get all that, but it's not up to me, and it's up to the landlord to make the decision.
Right. And so I don't know if this is the part where, because I was talking, so I got distracted. But there is a part that's most likely this part where the other lady that's not in the camera, but obviously in the car with the tenant, is making statements. And a part of the statement is, we want the judge to decide upon what is fair and make the arrangement. That's not this procedure. And as a matter of fact, they probably get into, maybe after this, but they get to a point where they're like, oh, that was my understanding that the court does it. No. So we're on YouTube today. We're learning, but this is not, as much as we call it YouTube University, this is not a true and complete education to all things. YouTube has a great set of educators, teachers of all kinds, but nonetheless, it doesn't replace learning at the university. So be careful watching YouTube. These are suggestions. These are, not all things fit in the same bubble. So that's why you have attorneys that look over the case of the facts of your case and determines how your case can be applied and applicable to certain codes and laws. Specifically, this is what I think the mix-up is. You already have a judgment against you. You're motioning to stop the collection of the judgment and to set up payment plans so that it's more advantageous for you, that you live in this place while you're still paying the past due balance and paying the current balances in accordance to whatever the landlord agrees to. That is contracts. That's a contract that you're trying to amend the original contract to help include this judgment that the court has against you, that you're trying to amend, agree, and to have agreement with the landlord for new terms or add-on terms to your current contract. So contracts are negotiable. Contracts are between one or more parties, and contracts have to be agreed upon in order for them to become enforceable. So consequently, whatever you propose, the other side has to agree. And then once you guys both agree, then you come down to the consensus and you move forward in that way. Now it's an enforceable contract. The court has enforced the original terms of the contract because that was agreed upon by both parties, and that is what is enforceable. But the court does not set funds for your repayment. What happens is the court will be deciding the case, and they will determine to open up escrow, and they will have a portion during that time pre-trial saying, okay, while we are collecting the evidence and we as a court take extra time to do things because we have a calendar, it's set out 60 days, 90 days, it takes so much longer than a couple of days. Consequently, we're going to have you, tenant, put money in escrow. Can you put the full amount into escrow? And if you're saying, well, I have a financial hardship, I can't afford this rent right now, they'll say, okay, well, how much can you put into escrow right now? You say, I can put in half. Okay, great. That does not mean that they have negotiated a new rent for you. No, your rent is still what the contract says your rent is. They have only made agreement with you to put in a certain amount of money to be held into escrow so that when the case is disseminated, when it's done, is resolved, they can take that money in escrow and say, okay, landlord, we have $2,500 from the tenant in escrow. They owe you $10,000. So consequently, take this $2,500, deduct that from the $10,000. The judgment is now for $7,500. Okay, tenant, you now owe $7,500 plus costs. That is what escrow is for. Now, there are sometimes that tends to put all of the rent into the escrow because maybe the claim is not a financial hardship. Maybe the claim is this place is inhabitable and I don't want to pay money to this landlord because the place is unsafe. There's mold, there's issues. These need to be cured before they get the payment. So they put all the money into escrow. That's a different scenario. But anyway, so we've done a very detailed way of understanding that these two things are not one and the same. The court does not renegotiate your terms. The court does not renegotiate your rent. Putting money into escrow for hold, that is a process to ensure that funds are being collected and the court is not, taking up so much time that it's costing the landlord not only the back pay, but whatever pay you could come up with now because, hopefully you're making payments, right?
Decision to bend the terms of your contract and let you catch up on it. And they were shaking their head here. $250 a month was just not enough.
Okay.
Now, if you could propose something like maybe $1,000 a month, they might go with that.
Okay.
How do you
Okay. With that being said, can I have someone advocate for me?
if they're a lawyer, yes.
Okay.
Nobody else can speak for you.
Okay. Take that into consideration. A lawyer can speak for you because they are an officer of the court, especially when you're an adult. Now, if you're under conservatorship and you're an adult, then your conservator would be the one speaking for you. They would be the one standing in your stead, and they might call you as a witness, but for the most part, they're speaking on your own behalf. But only under those particular circumstances, and you would have to have a legal conservator in order for them to represent any findings in court. Legal conservator can also be financial conservator, but there's also a thing called medical conservatorship, and that just is over your medical decision. So it has to be where they have standing in the law in the court that they can.
Okay, so
So
my thing is with the landlord is it's not like I haven't been trying to pay them. I've been trying to give them payments, but they won't accept any because they were saying that they can only accept the full balance. So that's the only reason why the balance is so high.
We're here now to talk about that. In my courtroom, in court, we can accept whatever I tell them to accept that we agree upon. Now that's their policy out there on the complex. They want all of it, and I get it. But we're here to talk about what you can afford, and maybe we could give you a payment arrangement that's acceptable to counsel. But $250 wasn't it. And Mr. Dyson, you wanted to say something?
Oh, Judge, this is her motion. I'm assuming.
Okay, before we get into his response, I just want to kind of make this plain. So if you have, if you're in eviction court, if you try to make a payment to the landlord or the property management company, under most circumstances, they'll say no. Because you're in eviction court and they want you to put the money in the escrow so that the ledger is going through the court and the court comes out with the final numbers in appropriate weight to what the escrow has in its account. Whereas if you're giving them the funds, then they now become responsible for reporting the amounts to the judge and the court, and that's just extra steps. And if they give it to their attorney to do, which they have an attorney, every time the attorney opens the file, it's a whole new charge. So they don't want to be involved in making the attorney open the file. So they're not going to take your payment. Even if it's a full payment, they're not going to take it until the court decides eviction. This is why you don't avoid court. Like she has a default judgment against her. She probably could have negotiated something during the trial time, during the time of the hearing, and said, you know what, I've been ill. This is my situation. I have $4,000. I have $2,000, whatever it is. I can make these payments. I would like to maintain possession. This is all of this argument she's making now is after the order has been come to, the judgment has been entered and the order is now in effect. So this would have been better during the trial. However, because of her illness, she can say, well, I was ill. I couldn't make it to trial. So therefore I'm asking these questions now. That's reasonable. However, the judge does not make the landlord accept payment arrangements or accept you staying in possession or accept you making monetary changes of any sort to the agreement. it is the judge mitigates. They call the balls and strikes. They make sure you stay within the bounds of the law, that the place is habitable, so forth and so on. And you say, well, I want to pay $1,000 a month off of this, this $3,000 that's owed plus my current rent. And then they say, okay, well, landlord, do you accept? And the landlord says, okay, that's fine, as long as they do it by the 15th of each month, and da 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 da. And that's them bringing in the negotiations of both sides. Then the order goes into effect if they make those changes. But they don't just arbitrarily come up with, okay, well, if she can pay $1,000 a month, you have to take it. They can't do that.
To set aside the original default.
I mean,
But
well,
she hasn't given any.
you can take $1,000 a month, but that doesn't mean you keep possession, I should say.
She's not trying to set it aside. She wants a payment arrangement on it.
Understood, but we have a judgment, properly executed judgment. She hasn't paid. The amount is now almost $3,000 more than the original judgment. We would like to dismiss her motion to have the rent executed upon.
So what are you saying is you don't want a payment arrangement with it?
No, not at this point. Just look at the amount where we are. It's going up and up. And the proposal originally was $250. It's just not going to work, Judge.
Are you able to propose more than $250?
Tell them. What you can tell them is that's why you're in a meeting. You're asking them what they suggest so you can catch up. If they give you an amount, you'll have it. You don't want to give yourself obligate. You don't want to put yourself under the obligation knowing your health risk. You don't want to say, okay, well, I'll give you this amount and then you cannot produce it. So you tell me what it is that I need to do.
Okay. So moving forward, can you tell me what I need to do?
Yeah, pay $8,000. The amount that's on the ledger. I mean, I don't know.
I put money into escrow.
So I totally feel the attorney in this matter. He's like, look, you pay what you owe and get out. He's like, we have possession now. We don't want to hear this. It's very interesting to me that this judge is allowing this other person to do all this speaking, but probably giving her some grace because knowing of the illness, having someone to help her might be a comfort to her. But don't try this at home, okay? Do not try this at home. Uh-oh.
So we can come up.
Okay, is that including the money that I put in escrow already?
No, the money you put in escrow, let's see. Can you look it up there? Because there's $1,440. There's another $1,440 in escrow. So
it goes against the balance.
She has $4,000 now. Plus she would have the escrow of $1,440. So that totals $5,440. And her balance is $8,726.02. And if we subtract the 5,440 from that, we get, now she would owe $3,286.02. Ma'am?
Ask me to repeat it.
You would still owe, with your money that you said you have of $4,000 plus the escrow of $1,440, that totals $5,440. And if we subtract that from the balance due of $8,026.02, your balance right now would be $3,286.02.
Okay.
Tell them, ask them if you can get on 400. Do 400 in 5 minutes?
Yeah. So, I'm sorry, I'm doing the math. Could we do like $400 a month?
Well, if you did that, it would take you 8 months to catch up, and you still have to be paying your regular rent.
That's fine.
And I don't think they want to go that far out. You're gonna have to come up with something that takes care of it within a couple of 2-3 months. I would say.
Supposed to do?
2 or 3 months.
Tell them you put that money in escrow. Have your half. They need to work with you. You're sick.
Well, I can't force anybody to work with her. The landlord doesn't want to work with her at all. I'm trying to see if we can come up with something that they could live with.
$400 on top of the payment is already is that's not taking 3 years, 2 years. It's not taking that much to pay back, and that's give or take. So that means she could still pay more. She just don't want to give that legal obligation to herself because she knows that she's sick.
Well,
so
if she doesn't want to, she's gonna get. This is not good enough.
She's still paying.
Okay. Yeah, I don't think you all understand exactly what we're doing here.
If she has if you owe $8,000, right? But not even the tools and fuels, you owe $8,000 and you already have $5,000 plus, right? So that's only $3,000. So if you split that up in a 6-month payment, you'll only be paying almost $500.
So I guess the biggest misunderstanding, of course, we don't know who this lady is that relates to her, who's talking in her background. But the biggest misconception is that rent is somehow like credit card debt. It's not credit card debt. You can't just roll over the balance. Rent is it's more like gas when you go to get fuel. It's probably a horrible analogy, but just stick with me. When you're putting gas in the gas tank, you go to the teller, you give them the 20, the 40, the 100, depending on what you got, and you say, put that on pump 3. You go to pump 3 and you pump out the gas that you just paid for. That's similar to rent. Rent is not for the previous month. Rent is for the month you're getting ready to occupy the property. So you pay the first month on the first, and then the first comes, the second, the third. You're living all month long, right? And then the next first, so the next month comes, and you pay the second month's rent, and the second, the third. So consequently, you're not paying it after you've enjoyed the property. You're paying it before. So it's like you're paying to stay in the property each month. So consequently, this particular concept of you already have 50%, over 50% of what you owe, and the balance once you put in the $4,000 and the $1,440, now your balance is just $3,000. So they should be able to work with you because $400. No, it's not about it's a balance owed, and therefore they're going to work with you, and you keep possession. Now they may say, I tell you what, you move out, give you a couple weeks or even a month to get situated in your new place and understand your bills better because you got to get adjusted, and then start paying me on the rest of the money's owed for the last however many months you didn't pay before. But it's not a credit card debt that can you roll over into the next month. So she's not doing them a favor by paying more than half of it. She's doing herself a favor because she owes the whole. That's the point. It's not helping them out. You're helping yourself out.
Almost 500. All you're doing is taking a couple dollars off. If you pay a couple dollars more, then I don't understand how that's so hard. And then you're still paying your rent. I can see if it's under, consensual.
Best statement she ever said. I don't understand. Here, you don't understand. So stop counseling her because you're getting her. Well, let's see.
You can't pay this or da 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 da. Okay, eviction. You got to go immediately. But if you're paying your money and on.
My daughter does that. Da 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 da. No. Complete sentences.
Top of the rent and then what you owe. I don't understand. They're still getting their money.
What you probably aren't getting is that she has a written contract that says she's supposed to pay a certain amount per month, and because she's in breach of the contract, so they're not obliged to take
what was the money in escrow for?
What you want. They can tell you that they might take something. I would.
But if you can't,
excuse me, ma'am, you don't even have a right to talk in this case. Okay. I'm just talking to you. So why don't you propose?
This, when you have friends like that, you don't need an enemy. She's going to say it's not that serious. So the comfort of where she lives and being able to stay where she lives is not that serious. That's poor advice. She's giving her poor advice, ill-advised. This has nothing to do with what is before her. And quite honestly, this type of negotiating conversation should have been had with the attorney. I understand she went down to the property management company, but she should have went to the attorney before this court hearing.
Ms. Daniels, something more than $400 a month, maybe $400 every 2 weeks. That would be $800 a month. Maybe they would take that.
Okay.
If you can do it. Don't propose something you can't do because you're going to get evicted anyway.
That's why.
Right. That's why we have to
bi-weekly. It's better than monthly.
Right. But that's why we're trying to figure out what to do in this case.
You don't have a choice.
I'm open to suggestions.
Pay the amount.
I just suggested try paying something bi-weekly. Maybe that would work because if you pay $400 bi-weekly, that would be $800.
This attorney is not giving any body language to say, okay, yeah, that might work. He's very stern, like, oh my gosh, Your Honor, oh my gosh. I don't think he's
that's really
right.
So if you divide $800 into your figure, it only takes 4 months to pay.
Okay, so should I go and speak with the leasing office?
How can you withdraw your money from escrow?
Well, you can always speak with your leasing office.
Right.
Right now, the lawyer only has whatever authority he has. The leasing office can do anything they want. The problem is they seem to have told him, at least as of right now, that they don't want to do anything.
Okay, so can I withdraw the money from escrow?
What do you mean?
The money in escrow in this instance is not much like an account, a checking account. So you just can't go swipe your card and take the money out. Now, if you're buying a house and you put money in escrow, you can cancel the contract and the money will be refunded to you. Yes, this will happen, less any costs and fees that are necessary. But in the instance of landlord tenancy, the money that's held in escrow is for your benefit in the sense that, you're not getting so far behind, but however much it is will offset how much you owe. And the court will have a trial and go into a case finding of facts to determine, do you owe the full amount or not? If they determine you do owe the full amount, then whatever is in escrow will be deducted from that because it goes to the landlord. It doesn't come back to you as a tenant. No.
Can you withdraw it?
Y'all not working with me.
Do I get the money back if I can't get anybody?
No.
Y'all not working.
I want to hear something.
What do you mean? Can you withdraw it?
Y'all not working with me.
Do I get the money?
What is she saying? Because even though she's not supposed to be talking, she's doing a lot of talking. Let's see if I can. Oh, let me go here. What is this woman saying?
Okay, so can I withdraw the money from escrow?
What do you mean? Can you withdraw it?
Y'all not working with me.
Do I get the money back?
So according to AI's closed caption, y'all not working with me is what the friend is telling her to say. Put it in the chat. Is this comment? Let me know. Is this friend helpful? No, not at all. But that's just my opinion. Maybe you have a different opinion. Is this the friend you want to have at your hearing if you have to go to court for eviction?
If I can't get anybody.
No, the money was in order to secure, they have a judgment of possession. And the law says you're stopping them from getting possession. They're entitled to the escrow because you owe back rent. So this is going to go to them regardless. It's going to cut down the amount you would ultimately owe.
Okay.
But what about the payment arrangement that's promised with the escrow payment?
This is a good case of non-understanding. There is no payment arrangement promised with escrow. It's not a payment arrangement. Like I said before, the judge in most instances will say, okay, your rent's $800 a month. Can you pay $800 a month now? And if you say you have financial hardship, then the judge will say, okay, how much can you pay per month? Okay, we're going to have you pay that in escrow. But that's not a payment arrangement. That is them holding as much as they can in escrow to go against whatever your liabilities are so that you're not coming up with a major judgment in the end. Just think about the cases that had to halt during COVID times. Just think about those cases like that March 2020, March 15, 2020, when, they closed the state and they started closing down the nation. And courts could only, I don't even know if courts were open continuously, but they, everything was brand new and different. If they had to wait 2 years for a case to come up with your final judgment and you weren't putting money in escrow each month, you would owe, let's see, 8,000 plus 16 is what, 32? How did I come up with that? No, 1,600, not 16,000. So you have $9,600 within each month times 2, $19,200. So you're going to be able to pay all that in one time? No, you're going to be, I don't have that kind of money. I can't pay all that in one time. So they let you put as much as you possibly can in escrow so that when the amount comes up, say you put $500 per month, now you have $6,000, $12,000. You have $12,000 to go against that $19,000. So instead of having to pay $19,000 all at one time, $19,600, you have $12,000 to go against it. So now you have $7,000 balance. Easier to come up with $7,000 at one time than it is $19,000. That's what escrow is for. Help set off the cost.
She's
right. So, okay. So from my understanding, the way that this is supposed to work is the judge is supposed to create the payment plan, and then it's supposed to be presented.
No. That's not how it works. I don't create payment plans.
Let her.
You have to agree with. You create it and you propose it to the landlord. They either agree or disagree. I'm a neutral person in the center, just trying to help both sides come up with something that you could live with. And right now, you have not proposed anything they seem to be able to live with. That's the problem. I don't create payment plans. It's not my contract. You have a contract with your landlord, not me. And I can't change the terms of the agreement. Only the landlord can.
Okay, so that's like my precursor. So what I said earlier applies to this portion right here.
Okay, I can't afford $800 extra a month.
Okay, well then we're going to have to go ahead and deny your motion to stay.
Pause.
That's the only thing we can do.
No, you're going to.
Did the girl just say pause? Pause. When you go to court, use proper English, complete sentences, and speak in application to the moment. You are no longer in the driver's seat. You filed the motion. Your motion is now denied. The court is now putting in their order. They're ruling against your motion, and that's just what it is because you don't have terms that the landlord's willing to agree to. Now, as the judge said, no matter what the judge does right now, at the end of this, yes, you can go to the leasing office and say, look, the judge denied my motion because your attorney wouldn't agree to terms, but I have $4,000 right here. If you can agree to, amend my arrears and let me keep possession, I can do this, I can do that. You can start negotiating with them if they want to, but they don't have to. You cannot make a person get into contract. That is illegal. Forcing a person into a contract is not, it's not legal. It's illegal. You can't do that. So, the judge can't make the landlord accept the terms that you propose. You can't make them accept the terms that you propose. However, you can propose such good terms that they will accept it. That can happen. You can negotiate, but it doesn't mean they have to. It's up to them if they want to. Anyway, this is why I say, friends like this, you don't need enemies, because this person who is off camera, nobody knows their name. They're not in this case. They're not listed as a witness. They didn't come before court under oath. They are saying all these things, coaching you what to say, coaching you how to feel, and all their advice is wrong. It's wrong, and you're paying it because we're looking at you. We see you on YouTube. We see you in the algorithms. We got you on our tube. We don't know who that was next to you. That person ain't got no smoke, right? They live in their life like life is gravy, and you're paying a bigger price because, I mean, I'm not making fun of you, but it looks like someone is, because entitled brat calls judge a dumb da 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 da. And it wasn't. I don't think she's an entitled brat. I don't agree with this. Sorry, I don't agree with that that title. But that is what they thought of you. And she wasn't even the one. This young lady is not the one who makes the statement. Okay, it's her friend. It's a friend who don't know what they're talking about. You can't listen to everybody.
I think we can do.
No,
Thank you,
you're
Judge.
You couldn't come up with anything.
Get you in trouble.
Okay.
No, scan it in.
Oh, okay, I'll do that. Thank you, Judge.
And do you have a writ pending? On what date was that writ?
I think it's in the system. I'm not sure the timing.
That's not what you want to do. You're not
But that's not what I want to do.
Well, ma'am, the law is not on your side on this one.
because you're not
I'm so
listening.
sorry that it's not. The order of eviction was presented on September 17th.
This, I really wish this young lady would have had that friend on camera, because she needs to be read her Miranda rights. Someone needs to read her. Okay, she needs to be read, reading Rainbow style. Take it all the way back, because she has completely misguided this young lady, and she is interjecting completely wrong and insane information. The law is not on your side, because the law that is written, the law is not on your side. The judge is enforcing the law. The judge is not the law. Okay, so be careful about that misunderstanding. And for this side lady, you know, this little bird over here to say, oh, that's because you're not listening. No, you're not listening. You're not paying attention, and you're not a part of this case. So you need to shut. That's the way I thought it. Oh, I froze on that. God didn't want me to say. I'm saying again, you need to shut up. You're not a part of this case, and you're getting this woman hemmed up, and it's unfortunate. That's not what she wants to do, but that's not what the landlord wants to do. The landlord does not want to let you stay, based upon the terms that you have proposed. They do not want to accept those terms. They want a dismissal of your motion, and they want their writ of eviction to go through. They want the judgment. They want you out. That's what they want. So because you couldn't hear them say that, because your side chick friend over there is hemming you up and talking all in your ear and giving you all wrong information, all that which was going into the court was letting you know. The attorney was letting you know, no, there's no agreement to any of these new proposed terms. We want to enforce the terms we already had.
Because you're not about to just move your money.
We still have time on that.
Because you're not
I'm so
listening.
sorry that it's not. The order of eviction was presented on September 17th.
Because you're not about to just move your money.
We still have time on that one.
Yeah.
Thank you,
So the
Judge.
written.
You hear a gas in her? Speak up. You're not just gonna move. Yeah, you are. You are. Thanks, friend. Thanks. Because of you, I'm moving. Because of you making all these stupid comments in the sidelines, I'm moving. Oh, they have to keep you there. Oh, you can't afford that. Oh, you can't do that. No, that wasn't helpful. What would have been helpful is if while she was sick, someone would have came and rented out the spare room or stayed on the couch or something and gave her a few dollars each month so she could have made payments on her rent. That would have been helpful.
It's going toward what you're doing. Did you just hear them add that money in?
I signed it on October 3rd. So writ dated October
Right.
3rd
So
may be executed.
Thank you, Judge. Have a good week.
All right, thank you.
So
All right, that concludes this.
So the whole case is over. Whole case is over. You haven't had a clue as to what half of what was said, because she's spoken about everything else, what you should do and how you got to do, and none of it applied.
Matter.
so you just let this dumbass bitch just do that? It's not.
So the disparaging comment was the friend talking to the tenant, which is interesting that the judge is the dumb one in the room. The educated individual with a gavel, law degree, and tenure of, at least being an attorney is dumb for knowing that in order to amend a contract, all parties must agree to the amendment. That is what we call that's like first semester, first month of law school, right? In contracts anyway. Like your first element of contract law is, in order for a contract to be enforceable, parties have to agree. One party proposes terms, another party accepts terms, and consideration is given, and they both agree. You can agree through your signature, you can agree through your actions, but you have to agree. Any amendments to it are an agreement already put into place. This is probably day 2 of contracts. Okay, any amendments to an agreement put in place must be agreed upon by all parties. And if the contract is in writing, and you want to amend that contract, you have to also have that amendment in writing. See, 2 days of contracts, 2 days of contract law right there. I don't know, my lighting is not good, But anyway, 2 days of contracts right there, and very easily to learn. Very easy, because this is the basics. This is the bottom line basics about contracts. How do you get into contract with someone? Does it have to be in writing? No, it can be verbal. What actions make it an enforceable contract? Abiding by the terms of the contract helps to support that the contract is agreed upon. And if you don't have signatures automatically show that the contract is agreed upon. Well, we amended it, Your Honor. Okay, great. Where's the amendment? Where's the amended document? So all that, and your friends, your homie, your girl, your ace, your ace boom coon. We're back to that thanks to Kendrick. We were bringing back old terms. But anyway, had nothing viable for you. The best piece of information or potential encouragement was given was that try to negotiate. That was the best advice your friend had for you. But the way of doing it, they have to, no one has to. And it's not to be insensitive to those who are going through disabilities. We talked about it before, but just in case you didn't see that video, not trying to be insensitive to anyone disabled or with an ailment. And, we do wish her all the best, and hopefully her body will heal and become whole, or at least into a place she's never in this predicament again. However, for us to really understand, just because a person has an ailment, a disability, does not give them the right to live in property rent-free. Okay? And you have to flip the script. If you're the landlord and someone is sick and they have COVID and they can't work, or they that was what the other lady said, or this, I think she said renal failure. I'm not sure what the ailment was that this young lady stated for us today, but whatever her ailment was, and she couldn't work for a while because she was going into treatment. Someone has cancer, they're going through chemo, they can't go to work. We pray for your healing, and we know that you're going to be strong enough to get through it. But if you were the landlord, you have to pay your bills. You have to pay the mortgage on the property. You have to, pay for the water or whatever, your agreements are. So consequently, you need the person to be able to pay rent. So if you can't afford to pay, see if you can get into a group, well, I don't want to say group home, but get into a shelter or some type of facility that will allow you to stay there, and the state funds help you to live there when you're sick. So you got to find if there's any such a thing for you, because I don't know, like I said, I think this is DC. I don't know if DC has those kind of social oh gosh, I can't think, I'm tired. Any one of those social programs, but other states or parts of the United States has it, such as California. We have social help that we provide to those who are ill in order to stay in their homes. We have VA, we have Section 8, we have group homes. Group homes keep coming to mind. I don't necessarily know if she would fall under a group home, but there might be a particular group home for young women. Usually it's women and children, but there may be, one that's just all women, all young women. And so you have to look into those things and see if that's available to you, or stay with a friend, or a friend come stay with you and help you pay your rent. Especially they can get you kicked out. But as I said, the statement that she was being a brat, I don't think she was being a brat. I really just believe it was the friend was completely misguiding her. But all the best to her. She has some money in her pocket. Sounds like she's going to be able to make a way and get through this. So we've learned a few things. I've been on my soapbox for a long time now, so I'm going to go ahead and let y'all go. Lyric Armstrong here, your real estate agent and advocate. Until I see you on the next video, make sure you have a happy holiday and like the video. Come on now. I don't need no other gifts. Don't cash at me nothing. Don't send no Patreon money, whatever they do out there in those YouTube streets. I just need you to like the video and subscribe. Help us out. All right. See you later.